Happy Wednesday to everyone. Hope you guys are having a good week. Hope everything's going well. Hope everyone is enjoying their week so far. And welcome. We're going to do a little recap. As a kind of a lead into this, I do want to, at the outset, kind of apologize because pulling up timestamps in this time period. I've been going live at 6:30 because Peter does his recap around 8 or 8:45, and I know that other people want to do recaps of the stream. This is a good time where I can fit in and give you guys a few impressions on what I had from a day in court. But it does kind of hinder my ability to pull up timestamps on a relatively frequent basis. So we'll have to just walk through this with me. So bear with me while I do this. Today was a little bit wild in court. Again, number 2,225 or day 22 of the Murdaugh trial. So had some developments at the beginning of trial, and I've put a poll up in the chat. I want to see you guys answer. I'm going to pull that down kind of as we get closer to the end of today's stream. See if Mr. Murdaugh is or is not going to testify. So I guess we're going to have to kind of gauge that one by ear as it comes. So before we go too much further, I did want to say that there's a relatively frequent visitor to the channel, Chrissy Lee, who's feeling a little bit down, isn't going to be able to make it today. She's dealing with some health issues. But I did want to do a brief shout out because I know she'll catch this on replay, and hopefully that makes her day a little bit better. As with all of you, I hope you guys are having great weeks. Please know that I know that your lives are busy, hectic, chaotic, and I really do appreciate all of you guys being here to catch these little replays as I do them throughout the week. This is different for me doing the almost nightly streams. It's kind of tiring, but I do very much enjoy it. So let's roll the intro and then get going into some of the beginning of today. Dun, dun, dun. See you guys in just a second. Okay, so day 22 in the Murdaugh trial begins with a motion, and the motion seeks a clarification. And I want you guys to focus on some of the words that we're hearing in this, and then we'll go back after the motion and kind of go through some of the pros and cons behind the concept or idea of Mr. Murdaugh testifying in his own defense, and think about whether someone in his position would or should testify based on the scope of the testimony that they're likely to elicit. So let's go ahead and start this thing off with the motion brought by Mr. Griffin.
Jury?
No, Your Honor. Mr. Griffin has a matter he wishes to address with the court.
Yes, sir.
Good morning, Your Honor. We are discussing with Mr. Murdaugh his right to testify or not testify. And one of the issues that has come up is the scope of cross-examination that the state would be permitted to go into should he testify. And the basic rule is when the defendant takes a stand, he waives his Fifth Amendment privilege as to matters to which he testifies on direct and relevant matters subject to cross-examination. Your Honor has let in, over our objection, evidence under 404B of financial misconduct. And what we're asking is for an order excluding the state from being able to question Mr. Murdaugh on cross-examination matters related to the financial crimes that's been put before the court under Rule 404B if we don't testify about those on direct examination. We need a ruling from the court at some point in time today before tomorrow. We're not putting them up today, but we're asking that we be able to advise him of what the state will be permitted to go into on cross-examination should he choose to testify. In order for us to adequately advise him and for him to adequately waive his right and his Fifth Amendment privilege and testify or not. And that's what we're asking.
Would you like for me to review with him at this time his right to testify or not testify?
Not at this point in time, Your Honor. We have to, we're trying to get a understanding from the court as to the parameters of the waiver of the privilege. Is he waiving, if he testifies about the murders, is he then subject to cross-examination about the financial crimes? That's what we're asking.
All right. Mr. Waters.
Before we go to Mr. Waters' response, I want to replay Mr. Griffin's opening question here because I want you guys to focus on some of the words he's using, and it might tip you off a little bit to where the inclination is on the part of the defense. So let's replay a little bit of that one, and I want you to listen to the words. Is he basically saying, if he chooses to testify, we want the limitation, or is it when he chooses to testify, if they're going to get a limitation? I want you to listen to how he makes that argument, because I think it's important for our understanding of how they're leaning. Dun, dun, dun.
To testify or not testify. Discussing, Your Honor, we are discussing with Mr. Murdaugh his right to testify or not testify. And one of the issues that has come up is the scope of cross-examination that the state would be permitted to go into should he testify. And the basic rule is when the defendant takes a stand, he waives his Fifth Amendment privilege as to matters to which he testifies on direct and relevant matters subject to cross-examination. Your Honor has let in, over our objection, evidence under 404B of financial misconduct, and what we're asking is for an order excluding the state from being able to question Mr. Murdaugh on cross-examination matters related to the financial crimes that's been put before the court under Rule 404B if we don't testify about those on direct examination. We need a ruling from the court at some point in time today before tomorrow. We're not putting them up today, but we're asking that we be able to advise him of what the state will be permitted to go into on cross-examination should he choose to testify. In order for us to adequately advise him and for him to adequately waive his right and his Fifth Amendment privilege and testify or not. And that's what we're asking.
Would you like for me to review with him at this time his right to testify or not testify?
Not at this point in time, Your Honor. We have to. We're trying to get a understanding from the court as to the parameters of the waiver of the privilege. Is he waiving, if he testifies about the murders, is he then subject to cross-examination about the financial crimes? That's what we're asking.
All right. Mr. Waters.
Thank you, Your Honor. May it please the court. First of all, obviously the general rule is that cross is generally wide open, and that goes for a defendant who testifies. Your Honor, Rule 611B on the scope of cross-examination expressly says that a witness may be cross-examined on any matter relevant to any issue in the case. And of course, Your Honor has ruled through 404 and 403 the financial matters independently relevant. But the rule goes on to further say, including credibility. So even if that had not happened, these matters which go right to the heart of the credibility and frankly the extensive dishonesty of this defendant would be relevant if he took the stand anyway, regardless of the 404. So independently under that rule of the credibility aspect, it would be admissible under Rule 611B. But again, Your Honor has ruled these matters as relevant in the case, and so that clearly within the scope of cross. Your Honor, citing State v. Gilbert and Colleton, 273 SC 690. They said right there, as I think the defense recognized, when the accused takes a stand on his own behalf, he waives his privilege against compulsory self-incrimination and must answer all proper questions. Your Honor, Taylor v. State, which I believe may have been overruled on other grounds, but 258 SC 369, when the appellant elected to testify, he waived his right against self-incrimination and became subject to cross-examination like any other witness. And then finally, citing the U.S. Supreme Court, Brown v. U.S. 356 U.S. 148, it says, it's talking about a defendant in a criminal case. It says if he takes the stand and testifies in his own defense, his credibility may be impeached and his testimony assailed like any other witness, and the breadth of his waiver is determined by the scope of relevant cross-examination. He has no right to set forth to the jury all the facts which tend in his favor without lying himself open to a cross-examination on those facts. Those are the general and well-established rules, Your Honor, and they're particularly relevant in this case. And so we believe that those financial matters would be well within the scope of this particular matter and authorized by the rules in the case law.
Mr. Griffin.
Yeah, just briefly, Your Honor, with regard to credibility, the rules are pretty strict as to what evidence of criminal conduct can be used to impeach a witness's credibility, and there are limited to convictions. and that's Rule 609. Your Honor has let the financial evidence in under theory of motive, and you've done a 403 weighing test. And Your Honor, I think when you get to cross-examination of a defendant, I think Your Honor has discretion under Rule 403 to prohibit the state from further inquiry, in this case, on the.
This is Court TV's feed. I noticed this when I was playing the recap. Not a whole lot gets added here. Dang it. Why did Law and Crime's audio cut during this portion? But it's their audio. It's not mine. Let me see if I can't get to the audio restored.
Untruthfulness, which this clearly goes
There you
to,
go.
as well as 608C, which talks about bias, prejudice, and any motive to misrepresent. And again, we're not just talking about purely dishonesty and credibility, which I think is alone more than enough. We're also talking about examination on issues that are specifically relevant to this particular case based on the 404 ruling.
Rule 607, Rule 608, particularly the portion of 608, see evidence of bias, prejudice, or any motive to misrepresent may be shown to impeach the witness, either by examination of the witness or by evidence otherwise adduced. Rule 611 and 609 also addresses the issue. I am not going to issue an order in advance limiting the scope of cross-examination. Any objectionable matter must be addressed as the evidence is presented, and not based on any advance ruling by the court.
Your Honor, the request for the ruling is not an evidentiary ruling. It's the scope of his privilege. And so would he be permitted to assert the fifth, for example, if they're permitted to ask questions such as they intend to on cross? And
if you see the judge shaking his head here, it's not because he's saying he can't permit he's not going to be able to take the fifth. He's saying it's contextual. He won't be able to make that call until he hears the questions. With this particular part, I think this is kind of a catch-22. So we're going to kind of walk through this. I'm not saying the judge is deciding one way or the other. This is one where the judge, I don't think, can make the call right now. And I'll tell you why in just a second. Let's finish up.
I can't give you any advisory opinions about the evidence and the scope of cross-examination, the scope of his privilege. I'm willing to review with him the scope of his privilege against self-incrimination, if that's what you're referring to.
we will certainly need to have that colloquy at some point at the end of the day, perhaps. But
for the court to issue some blanket order limiting the scope of cross-examination, that's unheard of to me.
again, Your Honor, I'm not, the question is the scope of the waiver of his privilege when he gets on that witness stand. That's what we're asking for, not an evidentiary ruling.
Mr. Waters has some cases there that I assume he'd like for me to look at, and if you do, I'd be happy to look at what you have as well.
Thank you.
Anything?
All right. So let's get some of the questions, and then I can explain the answers to the questions, because I think you guys all have very similar questions. Before we get into that, if you guys are here, if you're checking it out for the first time, you like the content, please subscribe. If you are here watching, please hit the like button. It really does help the stream and the algorithm to push a little bit of these recaps. I like doing these recaps on a daily basis because honestly, there's too much to try and recap after a whole week of testimony, especially in a case that's this complicated. So let's go through some of the questions that we've got, and then we'll kind of try to summarize those as best we can. So nothing to lose, admit financial crimes, deny the murders. Thank you very much, Nikki, for the super chat. I don't know. That's not really possible. And that's kind of what I want to explain here pretty much. 9 Nails Gal AM already pled guilty about the stuff brought in on 404, 403. Didn't he? Why the exclusion? No, he has not pled guilty to all of the crimes that are alleged. Those are set for a later docket. So no, he has not pled. These are not convictions. Thank you though. Heather, thank you very much. How do you feel about the ruling regarding AM testifying? I understand the ruling, but I'm not curious because he hasn't been tried for financial crimes yet. And won't that affect the trial if he's asked questions about it here? Yep, we're going to go through that. That's going to kind of be a bunch of the talk that we're going to go through is what was happening during this motion, because that's where I saw tons of questions coming in. Kathleen, thank you. Question, why wouldn't defense just object to outside the scope? Not really. And I'll tell you why in just a second. Promise, I've got receipts pulled up. Claude Simeon, I thought cross is always limited to what was indirect. No, not really. We'll go through that in a second. KC Cat, Manny Matney just tweeted that Alex is scheduled to testify tomorrow after John Marvin. If that's the case, this is going to be very interesting, and I'm going to be very interested to listen to that colloquy between the court and Mr. Murdaugh. Be happy. Does he have the right to plead the fifth on certain questions? That is subject to additional information and understanding about what he testifies to and how the judge might rule. I'll explain that in a second. Heather, thank you. Do I understand correctly? If he takes this, doesn't mean he can't plead the fifth. Yes and no. I'll explain in just a second. Tiffany Bernier, thank you. Any explanation for the lie about being at the kennels? Do you see any way of him getting that without him taking the stand? Thank you. I'm not sure. It's going to depend on how the jurors are viewing this information as it's coming in. It's really kind of interesting. This is a very dangerous thing for him to be doing. Lori Leanne, thank you. Thanks for the recaps, Rob. We will be lost on Friday. I don't know about that. We're going to try and do a Friday Night Frenzy from Texas. Misty, thank you for the question and comment. It's not contextual. It's either you plead the fifth or you don't. You don't get to pick and choose what law you like and don't like, in or out. It's that simple. It is, and it's not at the same time. I will go through the rules and the intersectionality of some of these rules in just a second. Della, thank you. I've been blocked by Nightbot over 20 times. Why? Nightbot is in the chat. Nightbot is a bot. Nightbot is not a person. So I'm sorry. Nightbot is there to kind of keep to help me keep my focus on all caps and all the other stuff that gets in there. I'm still working out some of the tweaks. So thank you. If you do want to DM me just with what things you're trying to send in messages that are getting blocked, that's something I can take a look at with some of the different things that Nightbot, who is rather adamant in their blocking, can what the confines they operate within. Jamie, Waters has a hard on for these money crimes, so it's unfair to me that he can't testify to the murders without being tried on the money crimes. It's conflicting. So without getting too into the weeds here, let's do this. Let's pull up the actual court rules. So let's do this. So here we go. Rule 611, mode and order of interrogation. This is what the court was kind of describing. Different states have different rules of evidence. This is from the South Carolina rules of evidence. I can tell you that in Virginia, generally speaking, the direct examination limits what can be testified to on cross. You can't really go into an all or nothing approach here in Virginia, that is. South Carolina is different. So this is their rule 611. So the court has discretion to exercise control over the mode and order of interrogating witnesses and presenting witnesses so as to make the interrogation presentation effective for the ascertainment of truth, to avoid needless consumption of time, and to protect witnesses from harassment or undue embarrassment. 611B, this is what Creighton Waters was making the comment about beforehand. A witness may be cross-examined on any matter relevant to any issue in the case, including their credibility. This is a very expansive look on cross-examination and how it's conducted. On any matter relevant to any issue in the case, which means that taking the stand allows questioning on any issues that are relevant to this adjudication of guilt. This then recaps some of the things that we've been commenting on throughout the trial. Leading questions should not be used on the direct examination of witness, except as may be necessary to develop the witness's testimony. So again, no leading on direct, and then you can recall the witnesses. So that's rule 611. There was another rule that was essentially argued by Ms. Griffin. That's this rule, rule 609, impeachment by evidence of conviction of a crime. So you can attack the witness's credibility on the grounds that they have been convicted of a crime if under certain circumstances the crime. So here's another one. If the crime, if the conviction itself shall be admitted if it involved dishonesty or false statement, regardless of punishment. That is 99% of the crimes that Mr. Murdaugh has been accused of or prosecuted for, or is included in that financial crimes case. So if he was convicted under those, that comes in, period, under Rule 609. But that's not the end of the inquiry here. So going on, then there's Rule 608, evidence of character, conduct, and bias of witnesses. So opinion and reputation and character evidence. So the credibility of a witness may be attacked or supported by evidence in the form of opinion or reputation. For example, the person has a reputation of dishonesty, but it can refer to truthfulness or untruthfulness only. The evidence of truthful character is admissible only after the character of the witness for truthfulness has been attacked. So he can put on evidence if he so chooses to say, I'm a truthful person. In this particular case, I can't see him doing that. It's kind of a lost cause. Specific instances of conduct. This is the more relevant inquiry. Specific instances of conduct of a witness for the purpose of attacking or supporting the credibility, other than conviction of a crime, may not be provided by extrinsic evidence. That means you cannot introduce extrinsic evidence to attack their credibility. You can't bring in additional information and say, isn't this a check that you signed on this particular date, if that hasn't already been admitted in this case. They may, however, in the discretion of the court, if probative for truthfulness or untruthfulness, be inquired into on cross-examination of the witness, 1, concerning their character for truthfulness or untruthfulness, or 2, concerning the character for truthfulness or untruthfulness of another witness as to which the character the witness is being cross-examined. And then finally, C, bias, prejudice, or any motive to misrepresent, which is oftentimes the case when you're putting a defendant on the stand, may be shown to impeach the witness either by examination of the witness or by evidence otherwise adduced. So all of that being said, that is essentially the scope of the court rules or the rules of evidence on this particular issue. So right now you begin from the premise that cross-examination, generally speaking, is permitted on any issues that are relevant to the adjudication. The court has already made a ruling under 403 and 404 that certain information was relevant for purposes of establishing the defendant's motive. So the relevancy test has already been met. Now you've got a different weighing standard as to what the court's going to allow as far as cross-examination is concerned. Then you've got an additional hurdle here, which is the Fifth Amendment privilege. Every defendant has the right not to incriminate themselves, which means they cannot be called as a witness by the state. The state cannot put you under oath and say you must answer these questions. That right is subject to being waived. You have the right to waive that privilege if you so choose. That waiver has to be informed and deliberate. That's why the court makes that inquiry at the very beginning, kind of saying, are you saying that we need to advise him now, or would you like me to engage in the colloquy about the scope of his privilege? Because the court, before a defendant takes a stand in a criminal case, the court has to advise the defendant they have the right not to testify if they choose, and that they are testifying willingly, voluntarily, and without duress or intimidation, etc. So that's what the court is referring to here. Now, here's the question on the fifth. These crimes that he is accused of committing, the financial crimes, there's sufficient evidence, I think, more than sufficient evidence in this case that they're going to be able to obtain a conviction. That said, there has not been a conviction yet, which then leads to a separate inquiry. The Fifth Amendment privilege extends to any risk that you might incriminate yourself for future prosecution. So technically speaking, he has the privilege to assert in various contexts throughout this. And a judge overruling that privilege or advising on this privilege has to be very careful to tread lightly in this particular realm. Now, Alex Murdaugh can go, pretty much kick the door open by saying, I didn't lie, or I did lie, or something like that. And then Creighton Waters or whoever's cross-examining him will essentially have the door kicked open. They'll do a colloquy before cross begins, just to clarify that these avenues are open for attack. But generally speaking, the Fifth Amendment privilege exists for those matters not being tried at that moment. That's why this is an interesting question. So, yeah, I think that I'm with the judge on this one. It's premature to make a ruling here. You're using Attorney Tom's two favorite words. It depends. It depends is every lawyer's two favorite words. If a lawyer says something that's absolute, it's kind of tough to get there. So we'll see. The Satterfield guilty charge, that might be admissible, period. I don't know. My question here is really one of, is this a smart move? What are you hoping to gain? And in every case, so there's certain caveats here. Self-defense cases, generally speaking, your mental state is at issue before the court. You're right. It's a right. It's a right. It's not a privilege, but it is a right that can be waived. So in that context, it's discussed as a privilege. With regard to whether a defendant takes the stand or not, generally speaking, in self-defense classes and self-defense cases, because their mental state when they engage in this act of defense is at issue before the court, while they don't have the obligation to take the stand, they cannot be compelled to take the stand. A lot of them feel that they are compelled to take the stand because they have to tell the jury why they did what they did. But then you actually have the admission of the act itself. In a self-defense case, the first thing you have to do is admit that you actually did the thing. You engage in the defense. At that point in time, then you're left with either an explanation that you give or no explanation except for circumstantial evidence, which is why defendants will take the stand in self-defense cases. In other cases, the burden rests on the state and it remains with the state, period. End of story. I got a lot of pushback on this one when I was making a comment about this yesterday of the state's obligation, the state's burden is to prove away all reasonable doubt. That is their burden. That's not subject to debate. Their burden is to prove away all reasonable doubt to the events that they have laid out and to their description of the case and their description of the crime and how it took place. The defendant doesn't have to put on a single word of evidence to defend themselves. If there's a hypothesis that the defendant elicits during the course of the state's direct, the defendant has zero obligation to put on any evidence to substantiate that hypothesis. None. They do not have to do it. They cannot be compelled to do it. And if the jury is seen, and if a judge or instruction is seen to instruct the jury that the jury has to hear additional information to corroborate these reasonable doubt or these reasonable alternatives, that is impermissible. You're not allowed to do that. You are not allowed to tell the jury that they have to see something more than just what they believe is a reasonable alternative. They're allowed to do that. So, and yes, Joe Tracy, I see in the chat, the operative word is reasonable doubt. Correct. It is reasonable doubt. That is why I made the comment that the state has to prove away all reasonable doubt. Now, the question here is, and the pushback I get during a lot of this defense case in chief is he's not doing anything to prove these alternative theories. Well, he doesn't really have to. If the theories exist, and if he has proven the framework, or if he's demonstrated there's a framework that could make those theories reasonable in the mind of the jurors, namely timeline being really tight, then that's a doubt that can exist. It can exist. And there might be jurors on this jury who one or two of them might believe that. And if one or two of them believe that, that's enough for a hung jury. That's what it is. So that's kind of where we are standing right here. And that's why I think that him taking the stand, I'm not sure that I would advise him to do it. But again, I'm not in that courtroom. And not only that, but I wonder about anyone in that courtroom at this point. And I am curious about some of the observations by people in court, but a lot of it's the gallery and a lot of it is a lot of witnesses and, a lot of it's the jury. And I don't know, because identifying a single holdout is difficult. So let me tell you right now, with his history of criminal activity, with the lies, with all of those things, I think it would be very difficult for him to take the stand. And here's why. What is he going to do? he gets up and he says, yes, I was lying during A, B, C, D, or E, but no, not right now. Now, here's the flip side of that coin. If he believes, or if his team believes that there's one or two holdouts that are there, but all that holdout needs to dig their heels in is the statement from him saying, I lied on all these occasions, but not with respect to here, not with respect to these murders, then that might push him to testify. I just don't think there's much to gain here. So with that said, that's kind of my two thoughts on the whether he will or will not testify. But I think some of the context about that can be gained in what is elicited from testimony today. So let's go ahead and do a little bit of this. We're going to go through some of the commentary that's given in the first couple of witnesses. We've got an attorney from the boat case who is representing Mr. Murdaugh. And let me do this real quick. I just want to pull up to make sure I've got the names right and the order of witnesses right, because I remember the faces, but names are something I always struggle with. So let me do this real quick. Pull this to the stream. We've got that. Dun, dun, dun. So now we've got, let's see, that was a lot of the yesterday stuff. Okay, Mark Ball. Mark Ball is Alex Murdaugh's former law partner. He now works at the Parker Law Group, so he is still a practicing attorney and is still active in the law firm. So let's listen to some of his direct, and then I want to listen to the beginning of cross-examination because I've been critical of Creighton Waters in his direct, and I want you guys to actually hear the fact that I was being critical of him in his direct because it was a style that should be reserved for cross, and I thought he was quite eager today with Mr. Ball. So let's see what we've got as far as Mr. Ball's testimony and where we can get with that. Because there was another thing in here that I thought was interesting.
Just as they could, which is what you do as a plaintiff's lawyer. You're looking for coverage. You don't want to make allegations that get you out of coverage. And it was very vanilla against him. And the allegations against Alec were that I sort of referred to him, and others did as well, as sort of bad parenting. You had a adult child that the allegation was that you allowed him to go out and drink. And when you're 18, you pretty much get to do what you want. And you've reached your majority. And so I thought it was very defensible as to those causes of action at that time, or that cause of action. And I think he did too, but I don't know what he thought.
Right.
All right. I wanted to play that little bit because in this particular instance, this is the attorney who's representing Alex in the defense of the civil lawsuit that was brought by Mr. Tinsley, who we heard from in the state's case in chief on behalf of the Beach family for the boat incident. And he said something that was pretty interesting, and it was that a person over the age of 18 has a certain amount of agency. And at what point in time can you still hold them liable civilly, hold the parents liable for conduct of an adult child? It was interesting because he essentially is saying this was a good defense. I'm not saying yes, no, I was saying that we saw from Mr. I was saying we saw from Mr. Tinsley in the state's case. Mr. Tinsley represents the Beach family suing Alex Murdaugh. Mr. Ball took over and represents Mr. Murdaugh in defense of that boat case. So Mr. Ball is one testifying, but he says essentially that there's a defense here. And from just a pure legal standpoint, there's a defense. There's a defense. And it kind of goes against some of what the prosecution's narrative is saying. And this is the defense in the civil lawsuit about where do you attach liability to a parent for actions of their adult son. It was interesting. So I thought a lot of this narrative was rather fascinating. In that case, he's basically saying, I think there was a defense here, so I don't know that we would have gotten all the way to trial. I don't know that we would have gotten the financial disclosures. And then as he's continuing to testify, Jim Griffin is leading a little bit and asking essentially, what was your opinion on what was your opinion on the merits of the what am I talking about? Yeah, this is a former law partner. Next guy, Rob. Next guy, Jim Griffin's as a law partner. This guy didn't take in to represent him. That's why I say I get my order mixed up. This is the law partner. He's testifying about a little bit of the defense that he thought was there. Mark Ball, law partner, friend. Yes, you're right. Wrong witness. Yes, you're right. Chad is right. I'm wrong, but I do remember that little bit of testimony here. Now, here's what I thought was interesting. We've got about an hour of direct examination. And then a lot of this was relatively vanilla. Not a whole lot here that really, I thought, helped Alex. What I thought was fascinating was this particular moment, because I was listening to this on like 1.5 speed, trying to catch up because I had calls this morning. And at 1.5 speed, let me tell you what, Creighton Waters talks fast at normal speed. Imagine listening to this intro at 1.5 speed.
Mr. Waters?
Please support.
Mr. Waters, could I steal one of your waters there?
Absolutely. There you go. He was pretty good at hiding who he really was, wasn't he?
Obviously.
You known him for 34 years?
I knew him for 34 years, or I have known him for 34 years.
Thought y'all were pretty good friends?
Also,
Interacted many times a week?
we had his son Buster and my daughter were in school.
This is why you check your notes, Rob. This is why you check your notes, because it was also the last bit of testimony here that I thought was rather difficult for the defense's case. So I struggled with this witness and wondering why they put him on. I very much struggled with it. He was a fair witness. He was absolutely a fair witness. I did not see anything that I didn't think was credible about this witness. He testified openly, honestly, and a lot of his testimony I thought was interesting. But listen to the end of his testimony.
Did it, some point in time, Alec, was he forced to resign from the firm?
He was. September the 3rd.
What day was it?
September the 3rd.
And after that, did you have an opportunity to look in his office?
I did. He resigned on the 3rd. Then there was the incident on the 4th. And I left the scene over there on Old Salkehatchie and went by the office. And I'd also been in his office on Friday after he resigned.
When you were in his office, did you find any paperwork that looked like he had been working on for the voting case?
Not until the 5th.
Okay, and what paperwork did you find on the 5th?
The 5th, I went in and started really, because we have an obligation to those clients that he was representing, and I didn't want files just laying around. This was Labor Day weekend. All this hoopla and emotion of, the murders, the issues with Alec leaving the firm, and then that Saturday. And so that Sunday I went in to the office and went to his office and started going through to make sure that any client files were put over in stack, over there. And as I was going through, I found checks that he had deposited with his telephone that were some of the funds that sort of started all this mess with the Ferris case. They were laying, one was on his top of his desk, one was in a drawer. I pulled out one of the drawers and there was a tablet, a legal tablet that had numbers written down on it as far as debts and assets and, just kind of the scribblings of kind of what you owe and what you've got.
Did I mean, would it be something that you would normally see on a net worth statement?
It would be the same information. When I think of a net worth statement, I think of the form that a bank sends you.
Right.
But yeah, it obviously, he was listing what he had and what he owed.
Is it something, the type of format you've seen in civil litigation where a defendant's required to produce net worth?
Not in the same form, but the same information.
I skipped another topic. After Maggie and Paul's death, did you collect her jewelry?
I did. I got a call on the Wednesday, I believe, after the murders on Monday from the coroner. His wife and my wife had worked as surgical nurses at Hampton Hospital together, and then my wife ended up being the supervisor of that area. And so I knew them very well, and I'd known Rich for 30 years. He called and said that Lori had cleaned up the jewelry, and whenever Alec wanted it, I said, well, I'll come get it. And so I met him, Ronnie Crosby, and I came over to his office and picked it up and signed for it, and I carried it back to the house.
And within the jewelry, you remember the wedding ring and wedding bands and other?
There were rings. I can't tell you. There was a thing that sticks out to me was she had a diamond bracelet on, and it was in pieces. And he said he tried to find all the pieces, but there was still some missing. But I wasn't paying attention so much to it. Just didn't feel right looking, snooping around in somebody else's stuff.
Knowing Alec for 30 years, do you develop an assessment of his relationship with his family, Maggie, Paul, and Buster?
Well, I'll tell you this. The person I thought I knew loved his family, or appeared to love his family very much. He'd take their calls. He'd do all of those things. After, September the 3rd, I'm not sure I know that person. And so, but he always seemed to be devoted to everything. Their ball games, he would aggravate the hell out of me when you'd be in a deposition and they would call and he'd answer it, and you'd be in a meeting or whatever, and he always took their calls. Whereas my wife and my children never called me unless it was a true emergency, and Alec took their calls, whether it was they needed, a gallon of milk, or, they had something important to tell him. I mean, he always took their calls.
And did you?
All right. In case you missed it, in case you possibly missed it, the person I thought I knew, and this was during Jim Griffin's direct examination. This is before any cross-examination takes place. This is during the direct examination. The person I thought I knew. I know people have said, did this witness sandbag the defense, or did the defense not see this coming? I almost refuse to believe that. These witness statements are gathered over a lengthy period of time leading up to this trial. And I will tell you that witness preparation, being prepared in these cases, means that everything that witness is going to say, even if the witness is adverse, especially if you are a defendant in a murder trial. You are not putting a witness on the stand that can go sideways. So here's my question. And it's one that I'm still playing out. And I have not reached a conclusion on this one. I'm probably going to toil over it for the rest of the night trying to figure out what the heck was going on. If you knew that this witness would get up there and say these things, why? Why would you put him up? I have thoughts about it. My thought is that some of the lies are so very obvious, meaning the kennel lie, that the defense has started eliciting those statements in their own case in chief. They're completely prepared to acknowledge that lie, which means they have to have a way of explaining it. And I don't know how they plan on doing that. I'm not intending to predict what they are or not going to do. But they had to know that this was going to be said. Or at least anticipate that it might be said. And if you look, I mean, I know people are critical of the defense and all the attorneys in this case, but the questions that Griffin is giving him leading up to this are not, they're not hardball questions. They're not one where you are worried about a witness going astray. You just get there. So the question is, are they going to blame it on the drugs? Are they going to blame it on, are they going to go with a tactic that I thought would be curious? It was every other lie was the lie, but it wasn't this one. And then try to put forward some alternative. I don't know what their plan is, but I cannot imagine the defense was out. Rather, that this was a surprise that this witness would say that, because Griffin doesn't even fight it. He doesn't fight back. He doesn't fight back on the person that you knew or anything else. He actually lets him expound. It was really interesting that this was kind of where we ended up here. So let's go into some of Creighton's cross-examination after we return from the break, because I do want to make it to one or two of these other ones. So I'm going to do a 3, 12, 11, 3, 12. Here we go.
All right. And then we're around September 2nd or something like that. And around that same time, Jeannie starts researching in y'all's system Forge, and then finds all the fake Forge checks. Is that right?
She used the query Forge to see whether anything had been put into an annuity, any fees had been moved or put under an annuity, and a list came out of, I don't know, 10 or 12 different cases.
And y'all called the real Forge and said, y'all have any of these clients? And they said no. Y'all ever banked at Bank of America? They said no.
We did, but in that list, like the fourth or fifth one was a client that I was representing, and the money was to be held in trust. And when we pulled up the documents, supporting documents, it had a notation on it that it was invested for 3 years, which I knew couldn't be. So I went and called the client. Client verified that he hadn't authorized anything, hadn't done anything. And I immediately told him that his funds would be put back in there. And I walked back across the street to Jeannie's office and told him we had a big problem.
And that was Thomas Moore, correct?
That was Tommy Moore. Yeah.
That was a highway patrolman who had been injured, correct?
Correct.
And Alex stole his money?
He did.
And they had been friends, to your knowledge?
As far as acquaintances, friends, I'm not sure what their relationship.
And I'm not going to go through in great detail because it's already been done. But generally, you and Jeannie were probably the main drivers of the investigation into all of this theft in States 314, this spreadsheet.
All of us were involved, but I was with Jeannie a vast amount of the time.
I'm sorry.
I was with her a vast amount of the time, going through and auditing them and checking to see.
All right. And ultimately, you had to reach out and talk to a lot of these clients of Alex Murdaugh's, right?
I did.
And you had to tell them what had happened.
I did, including 2 weeks ago or 3 weeks ago, another one.
And you had to tell them that Alec had lied to them, right?
I did.
And they said, Alec lied to me. He never told me that, correct?
Response?
I'll move on. You had conversations with all those clients, the clients that you dealt with, right?
I dealt with the majority of them, yes.
All right. I'm going to show you what's been marked as Exhibit 314. Just real quick.
So this is a dagger. I mean, all of this guy's testimony is a dagger. So dramatic. Yeah, so dramatic. But when you view the context of what this witness testified to, this was hard. Because it's hard for the defense to get around this. And that also leads me to the question of, did they not know what he was going to say? And I don't know. I don't know a single attorney that puts a defense case forward in a murder trial that puts on a witness they haven't thoroughly vetted. And it's just wild. So Mr. Ball was the treasurer for the law firm and was responsible for advising a lot of these clients that their money had been stolen. Imagine each one of those conversations, including clients of his own. Just imagine doing that. Walking up to your client and say, I know that you trusted us with all this stuff, but you know, the money's not there. It was stolen. We'll have to get it to you at some point in time. Just, I don't know. Now, take my original inquiry. You know what we're going to do? We're going to do this. I'm going to end this poll. And then we're going to see, so ending the poll right now, whether he's going to testify. Before we heard a lot of this stuff, is he going to testify? No was 60%. Yes was 39%. Okay, we're going to start a new poll. After hearing testimony from Mark Ball, is Alex going to testify? Mark Ball, right? Think so. We're just going to say, Mr. Ball, is Alex going to testify? My thoughts on whether he would testify or not, kind of, I'm going, you know, with that test, with him testifying there on the stand, I don't know that they saw that coming, but I can't see, I couldn't put my client on the stand after that. There's no way. I don't know how you get around any of this stuff. But again, that's not me. So let's fast forward to our next witness, 3, 50, and 24. And here we go. 350. We'll start from here.
You swear the testimony that you give today will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. Thank you. We'll have a seat up on the witness stand. And please pull that microphone to you and adjust it so that it's your height and you can talk into it. You'll state your name and spell your last name.
It's Morris Dawes Cook Jr., and Cook is Cooke.
Thank you. Would you please tell the jury a little bit about yourself?
I'm a lawyer, practice in Charleston, South Carolina with firm Barnwell, Whaley, Patterson, and Helms. I've been doing it since graduated from law school in 1979.
Preface: we have a new defense counsel that we had not seen throughout the entire trial. And I'm wondering why we haven't seen her, because she did really well. I would have put her on earlier in some of these crosses. She did great. A little bit, she was caught off guard in a little of the objections, but she did great. I thought it was interesting though.
Clerked for a judge for a year, and I've been with the same law firm since 1980. And I practice mainly civil litigation.
And do you primarily represent plaintiffs or defendants?
I don't mind representing plaintiffs, but most of the time I'm representing defendants.
All right. And do you know Alex Murdaugh?
I do.
How do you know him?
Through practice of law. I've had
Do you really
cases
know him?
against him over the years.
Okay. And have you represented him before?
No. Well, I mean, now I do, but I did not previously to this, right?
Right. What was the scope of your representation?
I'm defending him in the boat accident case.
Okay. And when were you asked to join his team?
In December of 2020, I got a call from Danny Henderson and asked me if I would become involved. The case had already been going on for a year and a half or so at that time.
Okay. And did he have other attorneys representing him at that time?
Yes. Yeah. The Hainsworth firm, John Tiller in particular, was representing him.
Okay. And what, if any, understanding do you have as to why you were asked to join the defense team?
Well, John was sick, as I think everybody knows now, and would be undergoing treatment from time to time, and he was unsure as to whether he'd be able to cover everything by himself. And so I was asked, one, to help him, sort of be a second chair for him, and also be a backup for times when he would not be able to participate.
Okay. And would you please describe for the jury your assessment of the merits of the claim against Alex in June of 2021?
Well, I think I was the one that coined the phrase negligent parenting that Mark mentioned during his testimony. The claim at that time was that Alex
Now you see why I got confused? Sorry for the cutoff. Now you see why I got confused? There we go.
was responsible for the boat accident because he knew that Paul was using his brother's ID. And I mean, I didn't think that there was a claim in South Carolina law for that. So I sort of facetiously called it negligent parenting. So we felt that it was a defensible claim. I always sort of felt that lurking out there was going to be what's now negligent entrustment, that eventually they would allege negligence for having let him use the boat, which is the substance of the claim now. But even that, we always felt like it was a defensible claim. That I think the big picture that occurred to me was to hold him liable for that would be to hold him to a higher standard than any of the other parents of the other folks that were in the boat, which anybody who's raised kids knows that that can be difficult.
All right, so there's some background. Let's get to some of his direct. So 403. Double check my timestamp. 403. And for those of you, yep, there we go. There's Mr. Tinsley. So there's Mr. Tinsley, who testified in the prosecution's case in chief. He represents the Beach family in this lawsuit. We all heard him testify both in the 403, 404, as well as to the jury with regard to what he believed was the fireworks that started this downfall. Now, I will say, it is in his interest to kind of say this was the down. A lot of people like Mr. Tinsley. I was curious. I didn't buy any of his argument about the motion to compel. None of it. I've handled so many of these motions to compel in civil cases. This argument about the order and what the order directed and told and how this motion to compel was the beginning of the end, it really, that just did not pass the smell test for any civil litigator. It just didn't. Sorry. Motions to compel are routinely kicked down the road. They're routinely ignored. These orders are routinely revisited. Even when the order compelling discovery is granted, the person doesn't, the consequence of not providing the documents isn't that you get the documents, is that you forfeit defense on some of the issues. So I don't know that this was the big gotcha that the state really offered it as. However, the state was allowed to ask Mr. Tinsley as to his opinions on the issue. Over objection, as I recall. And this part drove me a little crazy because we get to discuss the merits of the motion to compel from counsel representing Mr. Murdaugh. And the state makes an objection.
Yes, what we call a Form 4 order was issued around October 7th or 8th of 2021.
Okay. What is your understanding of that order?
I've got it right here. I mean, it said that John Tiller had not been able to get the information and that, well, it says right here, the court at a hearing on plaintiff's motion to compel filed October 16, 2020 was informed that defendant's attorney Tiller, because of circumstances beyond his control, is unable to gather and provide the necessary information to answer the requested interrogatories at this time. Once this information is made available to attorney Tiller, the court will schedule a hearing on this motion to compel if necessary, which means that John Tiller was going to get the information, and then if he couldn't work it out with Mark, then they would have a hearing on the motion to compel.
So was it your understanding the court was ordering Alex to produce all of the financial information requested?
No, that's not what it said.
Okay.
Yeah, Tinsley was passing notes to the prosecutor. Generally speaking, it's a big no-no. However, I'm at a loss for trying to describe this court's rules. Usually the prosecution team is allowed to converse with one another over the bar. That's that wall back behind the attorney's counsel table, but they're not
Right,
allowed to
just one or
converse
two more.
with third parties.
Did you
at
expect
that time.
any cataclysmic event on June 10th regarding Alex having to give over financial documents?
No.
Okay. And do you recognize Mr. Tinsley? Do you know him?
Yep.
The
see
little
him?
Yeah.
smirk.
Mr. Tinsley, can you stand up?
Oh, nope.
Okay. Did you ever speak with him
Oh, a
during the
little
case?
bit funny.
Yes.
You did?
A number of
Okay.
times, yeah.
At all about the motion to compel?
No, not that I remember. If he says I did, I couldn't deny it, but I don't remember it.
Okay. All right. Thank you.
Thank you.
By the state.
Like you said, the motion is meant to really worry the defendants, right? Those are your exact words, wasn't it?
Creighton Waters, breathe, my guy. Like breathe. Like I feel like we might have to put him in slow-mo to get through his opening here. And I don't blame him. He wants to go after this witness real quick. But I mean, this was probably about as aggressive as he got. Breathe and then approach.
All right. Thank you.
Thank you.
By the state.
Like you said, the motion is meant to really worry the defendants, right? Those are your exact words, wasn't it?
Could you repeat that?
You just testified that the motion to get those financial information is meant to really worry the defendants. Those are
Right.
your exact words, correct?
Always, yeah.
Okay. All right. And were you present at the trial lawyers conference when Alex Murdaugh came up and towered over Mark Tinsley and said, "What's up, Bo? What are you doing?"
No,
Were
I
you
don't
present
get
at that?
I don't get invited to that one.
I think you did. But you weren't there when that happened, were you?
No.
You were present for when he said that to that man right there about the boat case. "What you doing, Bo? What's up?"
Yeah, she makes an objection. This is you're allowed to lead. You're allowed to do all the leading, but you can't go up and do that type of theatricality. That gets into argumentative. So I liked how aggressive he was about it, but I think some of the theatrics can hang on for a little bit.
I was not there.
Basis for the objection.
Foundation.
It was a bad objection.
Objection is overruled.
It should have been a foundation. Should have been argumentative.
And you did not.
Said it wasn't there.
Okay, thank you, Your Honor. All right. And you didn't file your notice of appearance into this case until May of 2021. Is that right?
I think that's about right, yeah.
Because you were actually representing other parties, and that had to be resolved before you could get involved with Alec. Is that correct?
That's part of the reason our firm was, yeah.
Right. So you couldn't have been, with the conflict, heavily involved in any discussions that were going on between Mark Tinsley and John Tiller and Amy Bauer prior to moving into May. Is that right?
That wasn't exactly the reason. The conflict had been waived, but I just wasn't involved in that. That was something.
Great questions. Really interesting questions. I wonder how the jury is taking him in. I really, really do. Because the questions are good. And Poot does it too. And Metters does it too. They all do it. It drives me crazy. They're great questions, but does it have to come along with all of the flair, the leaning dramatically on the podium, the coffee cup holding, I don't know how it's playing. I don't know the answer to this question. Anyone who watches court, this is not what court looks like. This is not court. This is a court of craziness. I don't understand.
John and Mark were handling.
Right. And when John, in May of 2021, asked for continuance of that hearing on which the motion to compel the financial information was part of, he didn't offer you as any sort of backup because you weren't fully on the defense team at that point. Is that correct?
I think I had planned to notice my appearance before that hearing, and I can't recall whether I didn't do it because the case was continued, but I would have appeared at the hearing.
You were asked about insurance coverage, and you're talking about the Philadelphia policy, right? That there was a declaratory judgment.
Right.
And defense team knew that they weren't going to have any obligation to cover Alec in this, correct? I mean, it was very unlikely. In fact, it ultimately, Judge Sherry Lydon in the federal district court denied that Philadelphia had to cover Alec one penny, correct?
Yeah, I'll have to say, I wasn't following that, but that's pretty much my understanding. It was a long shot that there would be coverage.
And when you were at this point in time in June of 2021, just getting on the defense team, you certainly didn't know anything about his true financial condition, did you?
No,
You didn't know he'd been stealing money for years and years, did you?
no,
You didn't know that he was broke, did you?
no,
You didn't know he had misappropriated funds and was scrambling to try to replace those before people found out, did you?
no.
Good questions. And again, without the theatricality, it's pretty good. I like it. It's a good cross.
You were asked about the hearing on June 10th that ultimately was continued because of these terrible murders, correct?
Correct.
That's your understanding. The
That was
murders
my-
happened and that hearing got continued because, of course, who's going to have a hearing in the wake of these terrible events, correct?
Yeah, I think Mark agreed to continue the hearing. Right.
Yeah, that got continued, right?
Right.
And even as a civil defense attorney, even if you believe that a claim down the line may be defensible, that still doesn't change the discovery process in a civil case that goes on, correct?
That's true.
I mean, discovery still can happen and is going to happen,
Right.
regardless of whether or not the case settles or goes to trial or whatever happens, correct?
Yeah, it's still going on.
And that's how civil cases, typically how cases work in court, is that both parties.
All right. The point's been made by both parties here. And the reason why this witness is testifying kind of nonchalantly to the discovery obligation continuing is kind of what I described before. Everyone likes to say that discovery is this compulsory process where documents are produced and everything is magical and you can force and do all these different things. It's not that simple. It's really not that simple. Civil cases are different than criminal cases in that, and very specifically, people have pissing matches over discovery left, right, and center. It's just not the big thing that people think it is. And I get Creighton's point. Creighton's point here is very good. The point that when this attorney comes on and makes his assessment of the claims regarding discovery, that he wasn't aware of all of these different things. Good point made. But the notion that the discovery is being offered as this massive bludgeon, it just, I don't, maybe it's just because I'm an attorney that does that. Maybe that's why. It doesn't do anything to me. When we're arguing over the terms of this order, what I see this order as being is a by time order. And even then, it's not even indicating that there's a motion to compel that would be granted or could be granted. If anything, when you file a motion to compel, if discovery is given in the time since the motion has been provided, you kind of have to supplement your motion to say what's still missing. And then that kicks it down the road and kicks it down the road and kicks it down the road. So I don't know. I don't know if this is going to hold a lot of water, but in either event, let's get forward to the last witness I'm going to cover today. I'm not going to go to the cell phone guy because I actually want to pull the cell phone guy's testimony and watch it again and watch the testimony given by the state. I was fascinated listening to that, and I want to listen to it, and I want to give it the credit it deserves before I give any interpretation on it. But this particular witness, I did care. Did I miss the jackass moment? Yes, I did. Where Mr. Ball makes the comment that says, essentially, I thought the jackass was going to kill himself with regard to that September incident, which is something the defense might have known was coming. I don't know. So let's see. So we've got 4/16/59. Let's go to our next witness, 4/16/59. And this is going to be our last witness for the evening because I want to be able to wrap this up at a reasonable hour. And we'll start here.
Seat and adjust that microphone. to where you can speak into it well. And if you would, please state your name and spell your last name for us, please.
Yes, ma'am. Kenneth, last name Zercie, Z like zebra, Ercie. Good morning, Your Honor.
Mr. Zercie,
Yes, sir.
please tell the jury a little bit about yourself.
Uh,
Where do you live?
in Madison, Connecticut.
Okay. And what do you do in Madison, Connecticut?
Currently live with my wife, and my son lives up the street from us. Currently employed by the Henry Seeley Institute of Forensic Science at the University of New Haven as the director of training. In addition to that, I'm also on staff at the
I'm
university.
sorry, I can't hear you very well. Maybe it's just me, but.
I'm also on staff at the university as an adjunct professor in various forensic science disciplines.
Okay, let's talk a little bit about your background. You've been involved in law enforcement in your life?
Yes, sir, I have.
Tell the jury, please, where you began.
In 1974, I became an officer with the New Haven Police Department, also in Connecticut. Was promoted to the rank of detective. Most of my career there, for my 11-year duration prior to retiring, was with the Identifications Unit, responsible for crime scene processing, evidence collection, photography, and preliminary examination of physical evidence that's found at a crime scene. After that, I retired based on a disability. I was injured and was almost immediately hired by the state of Connecticut at the Forensic Science Laboratory located in Meriden.
I'm sorry, and tell me what that was again. What was that position?
The second career, if you will, was at the Department of Public Safety, currently called the Division of Scientific Services Forensic Science Laboratory. Originally brought in as a latent fingerprint analyst, also doing footwear and tire track examination, as well as becoming the senior person as far as crime scene related activity.
This witness was great. This witness was a very strong witness, and people were asking me questions and people were making comments that the witness was terrible. From an audio standpoint, this is a tough witness because this witness is exceptionally qualified and knows literally all the things that are done for forensics and has a lot of very great testimony to give. The sharpest witness so far. Yes, he was. And I really, really hope that on closing argument, they can bring his testimony to life, because one of the things that was frustrating, I did like what he had to say. The delivery was difficult. And this is the one part where I'm wondering if it was difficult for any of the witnesses to, or any of the people in the gallery to follow it. But he was very, very, very knowledgeable. He really did know this stuff. And I think that my assessment after this witness was done was that they left a lot of points on the field. There was a lot that you could have gotten from this witness. Started as a beat cop, was immediately went into detective work, then forensics, retires because of disability, then begins going into everything else there. This is the witness that you want, but you have to make this witness sing. You have to have a attorney that's doing the examination of the expert that knows how to make this witness shine. I made this comment yesterday regarding testimony that was given where, again, Mr. Harpootlian was doing the direct examination. And I really struggle with his examination of these expert witnesses. I really struggle with it because I don't think he's making the points that he needs to. Yesterday, it was with the engineer. And the engineer who had done a lot of the reconstruction, I thought, had a lot of information. It's just, how do you convey that to the jury? This witness has a ton of information. It's just, how do you convey it to the jury? And that part frustrated the ever living daylights out of me because this witness was great. He was great. He held up great on cross. He was brilliant. I just don't know that I would have chosen Harpootlian to do this examination because I think that there was a lot of points that were not hit upon. So let's go to some of the end of this testimony because I can't replay all of his testimony. I can't. It's too long. 6:25:37. I'm not fast forwarding through like a full hour of it because there was the lunch break in between. So let's go to about here. We'll play catch up. And I'm going to put him on 1.25 because between Harpootlian and this witness, we're going to pep up the cadence a bit. I'm not going to skip the spicy moment. We're not there yet.
Just trace amounts.
Okay. And you work your way to the front, taking pictures as you spray?
Yes, sir.
Okay. Now, once you've finished that, are you done with the floor?
No, sir.
What's now? What do you do now?
You want to take overviews to show the work that you have done, right? And show any modifications that you made to the scene. And again, make the determination, can I take the area that prints on with me? If it was a tile floor, we could pull the tiles up. But again, because it's on concrete, we'd have to rely on the documentation.
And these are still 90-degree straight down shots?
That would be the analysis part. You would still take general photographs on an angle showing the relationship.
But as you worked your way up and worked your way back, those would be vertical. I mean,
Yes, sir.
okay.
Those
And
would be
then you're taking general photos from different angles.
Yes, sir.
Okay, then what?
With digital, you would make sure that the photos came out, that you had an image captured, and that it was sufficient for whoever needs.
Okay, now
You would also take a sample of the blood from those areas for later typing or DNA analysis, should it be necessary.
did you find any evidence that they took a sample of this blood and analyzed it?
No, sir.
So we surmise it's Paul's blood. It could be somebody else's blood there too.
Possible.
And the only way you could rule that out is take samples.
Is to take a sample, do an analysis, and try to identify the donor.
And that was never done.
To the best of my knowledge, no, sir.
Okay. So then we have a number of surfaces. Let me have them put up number 26, stage 26. Okay, so, and just to cut to the chase, this is the door to the, well, I can see it a minute ago. There you go. That's the door to the feed room?
Yes, sir. The door frame on the right, door on the left.
Okay, did you see any evidence that they not dusted, that's old-timey language, that they processed that door or any other surface in the feed room for fingerprints?
Not to the best of my knowledge.
Now tell the jury, please, in a summary fashion, what you would have done. Well, first of all, do you have to see a fingerprint before you lift it or whatever you call that?
No, sir.
So how do you determine whether or not they're fingerprints you can't see? What do you do?
The base processing methods, again, depend on what technologies the agency has. The simplest and the oldest is dusting contrasting color fingerprint powder on a brush by just applying it to the surface and dusting it through. If a finger or palm or foot or toe has come in contact with those areas, the secretions from the ridge detail, right, leaves a pattern behind. Those latent fingerprints now become patent or visible. They can be lifted, they can be photographed. They also help tell you what was touched and how things were handled. So it would help in reconstruction as well.
That's the oldest technology there is though, right? The throwing dust down, fingerprint dust?
At a crime scene, yeah.
Okay. I'm not talking about going into the lab and using
No.
super glue or whatever. Say at the crime scene.
Yes, sir.
What is the more modern? Do you use lights or do you use chemicals? What do you do at the scene?
The first method would be to use an alternate light source.
What does that mean?
It could be
Alternate light
anything
source.
from a flashlight held at an oblique angle to see if you can find any smudges or smears. More sophisticated portable laser units, right? Laser is an acronym for a light source that produces a wavelength of light at a very specific number. The more common today are called the alternate light sources. These are various colored lights, and usually they're light emitting diodes or LEDs at different wavelengths of light. So in concert with a pair of glasses that are filtered, you can get a shift and you may be able to pick up fluorescence or luminescence. One of the problems is that our secretions, the oils, the fats, and the salts, don't reflect. They don't give off light. So you would need to process those, if you discovered one, with some type of chemical staining that would
I know that this is a little bit tough to go through, especially even at 1.25. And I will say that there's not a whole lot of gotcha moments in the direct examination, but I will say that this witness made it very clear that essentially SLED, as we've kind of gleaned from a lot of the case beforehand, SLED didn't just drop the ball in this investigation. This thing was just not an investigation to begin with. I don't know how much weight that's going to hold. So I did want to take this opportunity as I'm going to fast forward across, and I see that we have someone else joining for a moment. James, how
Hello,
you doing,
hello.
buddy?
Hey, good evening, Rob.
How are you?
I'm good. I'm doing well.
I'm going to pull this off the screen. How's South Carolina?
It's nice. It's warm, although I live in Florida, so it's not as warm as where I am, but it's an experience, I have to say. I mean, I like South Carolina. I've been here a few times. Walterboro's in between Charleston and Savannah, Georgia, so it's a nice area. The trial itself is a circus inside and out. I'll say that, being here for it. And you saw a circus at the Johnny Depp trial. This is a circus in a completely different way.
I have been rather astounded at a lot of the antics and the behaviors. And there's a point in here where, and I'm glad I have you here for this one, because it's during the cross-examination of the investigation expert, when Mr. Metters is doing the cross-examination and is standing right up next to that witness stand like he likes to do. And I think you know the moment I'm talking about, where he says, well, he pointed a gun at me yesterday.
Yes. Oh, yes.
We're going to get to it.
Okay. Good.
But we're going to get to it. But just generally speaking, my curiosity with you is, how have the attorneys appeared? Let's focus on the attorneys in the gallery. How have the attorneys been appearing each day? Frazzled, colloquial? I mean, tell us about that.
They've become more intense, I'll say. In the beginning, you had Harpootlian and Creighton Waters, right? That's his name?
Mm-hmm.
Okay. They were much more chummy in the beginning. Like during the breaks, they would, laugh. They'd even be together talking to the same group of media people, during breaks and things like that. It's much less so now. They don't interact as much. You see some of the other attorneys will interact with Harpootlian and Jim Griffin. But also, I mean, ever since the first, week, the Attorney General has been much more involved as well. So he's a very serious player now. And they really do have, the prosecution has a whole team of people that are talking the entire time.
How many rows do they take up on their side?
Three rows. Yeah.
That's
it's all team members. And then I guess sometimes witnesses will sit there, like previous witnesses and things like that. And I guess future witnesses, and then other just, analysts and experts and things like that will sit there, because the defense has like one row, and then you have the audience members. You had the Murdaugh family that used to sit in the second row behind them, but they were bumped to the back after, they were caught exchanging items to Alex and doing different things.
Mm-hmm. Which is funny that they were caught doing that and bumped back, and you had Tinsley reach over the bar today and give something to the prosecution. It's this courtroom has been just so unlike any courtroom I've ever practiced in.
Yeah. And because you're a practicing attorney, but from your experience being a, audience member in the Johnny Depp trial, there were a lot of rules, like no talking, you had to be quiet, you had to, do all these things. Not in this courtroom. This courtroom, the judge will just get up and walk out, and he'll get up and people just start talking like freely, and like it's loud. It's interesting. Yes.
Yeah. So before I go too much further, why don't you introduce everyone to who you are? You have a YouTube channel. You and I met during the Johnny Depp trial. You were standing in a line. Why don't you give everyone a kind of a little rundown before we get into this cross-examination?
Yeah, absolutely. I just started getting into covering trials through watching people like you and Emily and, other streamers. And I decided that I wanted to see the jury's reactions and report on it for all the people that don't get to see it. So I started it, I met you at the Johnny Depp trial. Now I've been here every day at the Alex Murdaugh trial ever since the first day of jury selection. And yeah, I have a Twitter and a YouTube channel, James from Court. So it's always, fun, interacting with you, but also interacting with your, the viewers and people online and everything.
Yeah, and you and I can sympathize on something because I know that you watch a lot of these recaps, and I do too, because I like hearing the impressions of all the other attorneys that are kind of listening and watching this case, because I like hearing the different interpretations of my colleagues. And I know that you've been doing that and trying to navigate your own live streams around that, but you have a stream tonight set up, right?
Yes, absolutely. And I agree wholeheartedly. I love listening to you and Emily and Kurt and everyone. I do have a stream at 8:30-ish, but 8:30, where I'll be going through basically just the reactions from the court. Also, I spoke with some of the defense about that moment where Harpootlian points the gun at them. So,
you got to talk to some of them, huh?
I did, and I spoke to the attorney, the former attorney general too, who basically, he gave me a really good quote. It was
Oh, don't ruin it.
okay,
I mean,
sorry. Well, everyone,
if you have one quote that you want to share, you can do that. But
Yeah.
I don't want you to ruin any of the juicy details.
no, I won't. I'll just say he said it was generally frowned upon, that kind of behavior, and then I'll go through more so of what they said. But I just thought that was funny. Generally frowned upon to do what Harpootlian did. And yeah, so I'm sitting there and just taking in all the behind the scenes stuff. So I'll be answering questions later tonight.
Yeah, and with how fast Court TV, Law and Crime, with how fast they cut the audio the second that things are done, it frustrates me to no end. There's like that tail bit of audio at the end, the witness gets off the stand, that I want to hear more than anything else.
Which part?
Oh, just every time a witness gets down off the stand, every time the court's done for the day, the mic feeds in the courtroom just cut. And we're just left going, because there's little tidbits you can hear on hot mics.
Yeah, that's true. And you don't get to hear kind of the buzz, I guess, and see what they're all doing. They don't really do much as far as like talking. Sometimes like after today, they just said a few things to the judge, but they often don't unless they show like the objections or things like that. But it's definitely kind of annoying that, especially during the breaks, that they cut away so quickly because, you don't get to see what happens.
All right. Well, if you can stick around, I want to get to this little moment and cross.
Absolutely.
I'm not going to take too much longer because I know that there's other people doing recaps at the moment. So I want to try to get to the last little fireworks and then wrap up and get you off to your stream and be able to catch up on a little bit of work that I have left to do from today, because that's how things happen. So here begins the cross-examination by Mr. Metters.
Mr. Harpootlian asked you if you, and maybe I think he told you, you had read all the records in this case, and you said yes, remember?
No, sir, I've been qualifying that each time he stated it.
I'm sorry, do what?
I have been qualifying that question each time he said that.
Well,
The records that were made available to me,
okay.
the entire case jacket was not made available.
So tell these folks what was made available to you.
Photographs from the coroner's office that were taken apparently by a photographer representing them at the scene. Photographs, I believe, were taken by SLED or an investigative agency. Later, I was the recipient of 4 images, now that I know were taken by the state, well, we call them state's attorneys, district attorney. Copies of the autopsy report, some of SLED's investigative reports, such as the fingerprint section, which actually also did the footwear examinations. Let's see.
And this is why you don't ask open-ended questions on cross. The witness
I was given access to the operations manual for SLED, right, and the letter that I just referred to as far as the origin of some of the photographs.
So you have not read all the records in this case?
Correct.
And you don't know who Laura Rutland is?
No, sir, I don't.
Would it be important for somebody, Well, let me ask you this much. When did you get all that, the reports and the pictures from, when did you receive those in your possession?
Some of them as long as 2 months ago, 3 months ago, others today.
And I spent the weekend looking through some of your background.
Yes, sir.
You provide reports in a lot of cases, don't you?
Yes, sir, I do.
Written reports,
Yes, sir.
what you do, what your findings were, correct?
Yes, sir.
And in fact, you do that in most cases, don't you?
Yes, sir.
Did you do a report in this case?
It was not requested.
Okay, well, so are you taking notes and are you just doing all that from memory up there?
Testimony so far has been more about procedural issues and the specifics of things that I've already reviewed.
I understand that, but that wouldn't answer my question respectfully. Have you done a report for yourself?
Do I have notes that I was taking? Yes. Do I
You
have
have
copies
those?
of do I have them with me?
Yes, sir.
Strictly what's on my computer,
You want to provide those to me?
if you wish.
Entitled to reports, not his notes.
And I want to cut this off here real quick. This is a red herring. I've made this comment several times on the interwebs. This is a red herring. These questions, it's the same kind of stuff that Dick Harpootlian did when the state had experts on the stand. You are not obligated to provide anything other than the report when it's produced. And most attorneys will not require or request a written report for that very reason, because they don't want to turn it over in discovery. It's done by both sides. The only difference is the prosecution has to turn over all of the notes of their investigators. That's requirement. That's a Brady requirement. So Harpootlian chimes in with an objection, kind of saying, this isn't Brady. You don't get everything. You don't. These questions are a little bit outside the field. And I thought that going down this becomes a pretty big issue, because it implies to the jury that this person's being shady. There's really not a whole lot there. I will tell you that I will get reports that were finalized the day of trial all the time. It happens a lot. And you jump, you stomp, you kick, you yell, you do all those things. You just, yeah. Not really. Nope. The rules don't really entitle you to notes. They don't entitle you to that. They entitle you to get information that form the foundation of his final conclusion. But if he hasn't made his final conclusion, you don't get that yet. That's the caveat. So basically, the prosecution did this with their experts. The defense does it with their experts. Both of them are saying these people are shady. That's what it is. It just doesn't carry a whole lot of weight. It does it all the time. So the objection itself, I think it's overruled.
Notes. He's not entitled to Brady. He's
Oh,
not
here we
entitled
go.
to anything
Yeah,
but a report under Rule 5. And there is no such thing.
He just said if you wish. He just told me I
I
could
didn't
have them.
ask for argument. The objection's overruled.
You said I can look at them?
They're not physically here, but whatever I have at another location, you're more than welcome to.
You said you had them on your computer.
Not all the handwritten notes, right? Any of the documentation I was given was by virtue of digital copies.
This is the intention of the question.
You have something
It's
on
all
your
up.
computer up there. You
Why
actually
the
motioned
question's
for it.
asked. That's why it's objected
Please?
to.
You have some on your computer up there. You
Not the
motioned
actual
for it.
notes, no. I have the actual documents I received to review. The handwritten notes or any of the notations on images or photographs are at another location.
When did you prepare? We got the PowerPoint last night about 10 o'clock. When did you prepare that?
Which one?
Was there more than one?
There were two.
Where's the other one?
They were both shown.
There's
Those
one
are two
PowerPoint.
PowerPoints?
There's merged.
There were two separate ones, yes. I take it back. I was mistaken.
You're what? What'd you just say?
I said I was mistaken.
Okay.
There was one PowerPoint. There were two sections to it.
When did you?
Never, ever underestimate an attorney's ability to take a single word that they hear in any examination and jump on it like it's the most important thing in the whole wide world. This is completely plausible. I'm not making an excuse for this witness. I thought this was the case with the state's expert witnesses too. It was interesting. And Mayor Kai, I think this is a good point. As much as the witness's party was given limited information by the defense, which makes his testimony not that relevant. I disagree with the premise that the information he was given makes it less relevant. He was given the information that he said he needed to make the assessment, and he holds firm in that regard. I think that issue was not properly clarified again, and I go back to Mr. Harpootlian for not doing what I thought he had to do, which is to make this evidence come in cleanly. And he just didn't do that. It drove me nuts. So Metters jumps in on this whole, you were mistaken. Well, yeah, you provided the report at that point in time. I know you guys are going to disagree with me on this one. I will tell you from a pure litigation standpoint, as a trial attorney myself, these antics are played on both sides. It is always ridiculous. It is always gamesmanship, and they always do this junk. But they're playing within the rules. It is part of the process. So let's get to this little blow up moment real quick.
Sure.
Apologize.
No problem.
Mr. Dorsey, 5'6", and I'll stand back here so everybody can hear. Sorry. 5'6" and 5'6'4" are pictures of Paul's shoes and Alex's shoes, correct?
There are photographs taken at the laboratory of the two articles that you mentioned by ownership, apparently.
Okay. Who've been identified as Paul and Alex's shoes.
Okay, yes.
Yeah. And then what are these, 561 and 560?
Depending on the methodology that was used, either placing a slurry of ink on the bottom of the shoe, rolling it onto a contrasting surface, i.e. a piece of paper, of both, you have a set of the left and two sets of the right shoe, right, to try to record any of the detail that would show in a two-dimensional impression when the shoe comes in contact with the surface.
And that's 589 and 559, I believe, are the right shoe. And 560 and 561 are the left shoe of Alex Murdaugh. Would you disagree with that?
No.
Okay. And that's good to do, isn't it?
Yes,
No question about that.
it's part of the examination process.
Take a picture of the soles,
Photograph the items,
do an imprint,
life size, not as represented in those pictures, but yes.
because you're trying to see if they're characteristics, correct?
If you have something to compare them to, yes.
Class first.
There's 5 criteria: size, shape, wear, pattern, manufacturing, and the final one is individual. The accidental cuts, scratches, gouges, or residue that may be stuck in the bottom of the shoe that would leave a pattern behind.
General class, and then see if you got some kind of individual defect, or I pronate, so that would show on my shoe, wouldn't it?
Yes, sir. And if you supernated, it would too.
Say what? Super, I got you, my bad, I didn't hear you.
Has to do with the way the foot flexes at the ankle.
I understand, I didn't hear you. In 198, 199, are already in evidence, would you dispute that these were the right and left of Paul?
They were shown to me as representative of that, yes.
And that's good.
Yes,
That's good law enforcement.
that's part of the examination process, yes, sir.
And what's now been admitted into evidence, SLED's report by Special Agent Worley, 2 reports, one more detailed than the other, where she basically gave her conclusions about
Worksheets. Under the
105.1.
under the accreditation, these notes would have been taken contemporaneous with the examination that she was conducting. All right, now there may be a typed transcript of those. And could you repeat which section again?
You got my mark.
There's a mark on 103.2. And you have an underlined section on 105.1.
105.1. Read my underlined section, please.
strictly that out of context?
No, you read it all. I didn't mean that. You read everything you want. Tell them about what she did. Tell her everything.
No, this is what Agent Worley did. From her examination worksheet dated 6/23/2021, right, regarding reliability tested, not applied, right, examination notes, subsection section 105 for item 105.1. Unknown footwear impression in photograph number 0139. Each photograph that was taken has a specific number assigned to it by the digital cameras. So you can go back to that specific image. Near the feed room door threshold. This would be, to me, it's closest to the entryway itself. The item 105, unknown footwear impression, consists of partial impressions in suspected blood on a cement floor. The outsole design consists of at least 4 rows of parallel rectangular blocks. One block is in a row by itself and appears to be 2 blocks that are joined together, forming more of a V or a U shape. Due to the amount of suspected blood, right, in the impression, it is difficult to determine if those or any of the blocks that appear to be joined together are actually joined in the design, or if the volume of suspected blood is masking the separation of the joints. The sentence with the underlined section. Overall, the item 105.1, unknown footwear impression, is consistent with the outsole design of the item 103 right shoe.
That's consistent with Paul's shoe, correct? Assuming Paul's shoe is 103.
It's consistent with that one that's represented, yes.
Thank
Okay. Again, this is her opinion.
I understand.
All right. Specifically, the unknown impressions appear to be consistent with the 2nd through the 6th rows of the toe end of the outsole. There is barely a noticeable difference between the design of the left and the right shoe. However, there is a slight variation in the slant of the blocks, especially in the middle row of the impression. Additionally, it is the photograph where, if the photographs were true to size, there is an outline of the blocks that would align with the 5th row of the toe end of the shoe, which is obscured in item 103, left shoe, but is clearly visible in the right shoe. Due to the quality, of the impression, a more meaningful conclusion cannot be rendered. The item 21 and 95, right, have been eliminated based on the outsole design.
So,
Those would be Paul's shoes and Maggie's.
so she found that was consistent with Paul's shoe, correct?
Based on her opinion, yes.
Okay. And I'm not going to go through every one of these, but I would just want to briefly go through. Did she also, on the 105.2 footwear impression,
Trying to find the exact moment, guys. I really am.
say that Paul's shoes were consistent?
And continues, the lack of clarity in the impression makes it difficult to determine if it was made by the left or the right shoe. Therefore, a more meaningful conclusion cannot be reached. And they were eliminated.
It's consistent, correct? The lack of clarity make it difficult to determine a more meaningful, but it's consistent, right? They weren't eliminated. Why'd you say that?
I read the next line.
Yeah, but that's item 21 and 95.
Correct.
You were trying to imply that.
No, I wouldn't do that.
You made a mistake?
No.
Well, you said they
The
were
last-
eliminated.
I object to him standing up, badgering this witness next to him. He can read it. He can comment from back here. He's in the doorway, but again, I object.
For clarity.
This moment.
He's been
The
up there.
objection is to you standing in the doorway.
He's been standing up here the whole
No.
time. Aimed a gun at us yesterday.
Pardon?
He aimed a gun at us from here yesterday.
Good for the goose, good for the gander is a rule, and I can't find it in my rule book.
Well, we're operating with limited space. Just as a matter of trial procedures, extremely unusual for counsel to stand in the locations where counsel have been standing throughout the trial.
Well, Judge, why didn't you do
Given
anything about
limited
it?
space, that's somewhat understandable. But he has moved to the podium. Go right ahead.
That part. All right, let's go and watch that little exchange again. So I don't think that Metters is badgering at this point. You haven't gotten to badgering. The questions preceding this one might have been a little bit because he's trying to jump in on words and not let him answer the question. Let's replay the question that led up to that, and then I kind of want to get James's impression on how the courtroom laughed, and like just this part drove me beyond wild because it's not a matter of having a big courtroom. When you have a small courtroom, you know, you make things more organized. You lay down the law. You basically say, this is what is going to happen in front of this jury. This is what's not going to happen in front of this jury. A lot of the stuff that's been happening as far as the attorneys going up to the witness stand, and I'll explain that in a second, but because I want to watch this last bit of question. Here we go. We're going to get to the point where the objection is made, and then I will kind of pause it and then go back.
Say that Paul's shoes were consistent.
And continues, the lack of clarity in the impression makes it difficult to determine if it was made by the left or the right shoe. Therefore, a more meaningful conclusion cannot be reached. And they were eliminated.
So he's hovering. That's a no-no.
It's consistent,
only
correct?
if the
The
judge
lack of
corrects it.
clarity make it difficult to determine a more meaningful, but it's consistent, right? They weren't eliminated. Why'd you say that?
I read the next line.
Yeah, but that's item 21 and 95.
Correct.
You were trying to imply that.
No, I wouldn't do that.
You made a mistake?
No.
Well, you said they
The
were
last-
eliminated.
Objected in standing up, badgering the
All right. So let's get to that moment real quick. We'll break that down just pretty easily. One, when you have given the witness something to review, you cannot take it out of their hands and then give it back to them, take it out of their hands. You don't get to do that. You actually should have a copy up there that the witness can review, and then you can actually instruct the witness to go to a certain line or highlight something. Okay. That's one part of it. Two, you actually have to let them answer the question. If your question is so bad that it requires clarification, as the witness is kind of going on to here, you can't cut them off and try to catch them in trying to understand your question. And then when you snatch the paper out of their hand, yeah, all of these things are bad. I don't think I would call them badgering. I think the objection was appropriate. But then Poot just does Poot. He's just going to just make Mountain out of something that could have been corrected pretty simply. So it's like you have one theatrical performance by the prosecutor, and then you have another theatrical performance by the defense attorney. And then at the end of the day, the prosecutor takes back the reins of the theater. And you have this
witness next to him. He can read it. He can comment from back here. He's in the doorway, but again.
Love the way the objection is made, though. Here's the thing. The objection goes too long. Don't do the speaking objection. Bad. But the instruction, the implication of the conclusion being given is a very firm way of objecting. It's basically telling the judge, he can or cannot do this. Well, the judge is the one that gets to decide whether he can or can't. But when you make the objection that authoritative, it has a little bit of weight. Now he just keeps on going.
Object.
Yeah,
For clarity.
this moment.
He's been
The
up here-
objection is to you standing in the doorway.
He's been standing up here the whole
No.
time. Aimed a gun at us yesterday.
Are you?
He aimed a gun at us from here yesterday.
All of that dialogue, I can tell you what would have happened in Fairfax, Loudoun County, Arlington County, Alexandria. If that had happened in that courtroom, the next time the jury was excused, all counsel would have been dragged up to the bench, admonished, and said that you will each be depositing at least $1,000 to the clerk of the court for all of the antics, and they're not going to happen again. And this has really driven me kind of nuts. The laughing is cringe. James, you there?
Yes, I'm listening and I agree 100%.
So let me have it. Tell me what's going on in the courtroom and what the hell is happening.
Well, and I've spoken this before. It's almost like this is accepted and it's just normal here. It's very odd to me, but yeah, the entire courtroom, erupted. And, I react, I laugh too at times, but I feel uncomfortable doing it. I feel like I shouldn't be doing it. It's like, it doesn't feel like appropriate. And the few times during the Johnny Depp trial, I mean, that was like the most at all, but otherwise there was no laughter or things allowed. And other times I feel like courtrooms across the country, you don't see that as much. Now, I will say the judge was not amused. He was not laughing, and neither was the jury. But the gallery seems to have no problem interacting like that. And the defense laughed as well. I mean, I didn't really see the prosecution because I sit right behind them, but I guess you could see on the live stream.
Well, and yeah, so you know from having observed in Fairfax because you've seen other trials. So I'm
Mhm.
going to tell the in normal trials, that little space between counsel's table, the judge's bench, and the jury box, that's called the well. That is the area where argument is usually allowed to be made because you're arguing to the jury at that point. You're allowed to approach and make argument in that little sector. While a trial is going on, the well is owned by the judge. You must ask permission to enter the well. You must ask permission to approach the witness. You must ask the permission to do all of those things. You are not allowed to be in this space where these attorneys just are hanging out and doing all their stuff. And you most certainly aren't allowed to hover over the shoulder of a witness, especially an adverse witness, while they're testifying, ever. It is one of the wildest things I've ever seen. And the argument of, well, he's been standing up here the whole time and he pointed a gun at us. It's like, this is all of it just doesn't make any sense. The prosecutors laugh, defense laughs, everybody laughs, but this is not how courtrooms work. In the Depp trial, if anyone had watched this, anyone was on this live stream had watched that trial, you would always hear the witness or always hear the attorneys ask for permission to approach the witness. That's how it's supposed to be. I would never approach a witness. Heck, I usually ask the bailiff if the bailiff would be so inclined to pass the document I have in my possession, give it to the witness because I have another copy in front of me. It's just, what the hell's happening?
Yeah, I don't know. It's very uncomfortable. I'm not going to lie. And I don't know if it's this court and this county. I will say that a story I heard about the Murdaugh family a long time ago, I think it was the grandfather when he was a lawyer in this courthouse. He took a tire and he was trying some case. He actually got famous for it. Had to do something with tires. I don't know. He was defending someone or suing someone. But he opened the doors of the courtroom and rolled the tire down the middle of the court, like into where the judge is. And that's just, I guess that was fine. And people liked that. And he ended up winning that case. So I don't know if that's just how things work down here. I'm not sure.
I don't know. There's moments where it feels like My Cousin Vinny. Just not a good version of it.
Yeah, it's weird. I mean, I wonder though, because the jury doesn't really seem to be as amused, and they're the ones that have to sit all day and they're getting paid basically next to nothing. They're missing their times with their family and work and stuff like that. And I feel like the attorneys in the courtroom sometimes treat it like a circus and like a joke sometimes, especially when they do things like that. And I don't know if that has a great effect, especially on a few of the jury members who I saw were like extremely put off by that moment,
Mm-hmm. Yeah. I mean, that's the thing with sarcasm and with jokes. Sometimes they land and sometimes they don't. The problem is when they don't land, they really don't land. So that's why I kind of stray away from them because they're risky. And in a murder trial, I don't know that you want to go down that road, but heck, that's kind of where we are. The judge basically said people have been standing everywhere. Well, ultimately that's on the judge. You have to step in as the judge and say where they can or cannot stand, make the rule. Like I said, the next break, I would have pulled every attorney up and said, no more of this crap. This isn't happening anymore. I don't care who you think you are. This is my courtroom. And I can tell you right now, I've had attorneys pull up, me and opposing counsel and told us to drop the antics. Well, we really didn't like each other. which is kind of the thought process that I have here with Putin Medders. They love getting on each other's nerves. Do they even look at each other in court, James?
Not really in court, no, but things are very different behind the scenes. They do. I mean, they'll like pat each other as they walk by or like smile and stuff. But who were the two people that you said? I didn't catch the second name.
Medders and Poot. Dikar Pootlian and John Medders. The Medders was the attorney we just saw there.
Oh, yes, him. Well, he's one of the ones I don't see him as much, and he doesn't interact as much with the other ones, and especially like across the board. I don't know if he just doesn't know them as well. Like, Creighton probably knows the other attorneys from, working with them for years and years. But no, he seems to be more kind of, he keeps to himself a little bit. He's kind of in and out when he comes in. I don't even see him actually talk to the media that much like the other ones do.
Yep. Well, there we are. So that's the end of the recap for today. I'm going to go through super chats. James, I'm going to say that it's about 8:30. I don't want you to start your live stream late. Why don't you jump off, start your stream, and then you guys can go and get his take on the trial. I love what you're doing, buddy, and I love the fact that you're really taking this investigative reporting stuff to heart. It's really pretty cool.
I appreciate that, and it was good talking to you as always, and I will see you shortly. If you have any questions for me or anything you want me to keep out from, court, always feel free to let me know.
I will. Thank you for jumping on.
Good night, man.
Night. Okay, so let's go through the super chats and then we'll wrap up for the evening. So Dr. R, criminologist, thank you very much. With AM's narcissistic behavior, he's going to testify whether Jim or Poot tells him no. He's going to think he can walk his way out of it. That was part of the argument that Griffin was making. He needs to be able to advise his client. Heather Miller, thank you. I think he will, so he can say I came clean about everything else, so why would I lie now? I think that cuts both ways, though. I think you might be right. Professor of Logic, thank you very much. Trial spoilers, here comes sarcasm, by the way. Alex took the stand, then shouted, "Nib high school football rules." Everyone cheered. All charges were then dropped. Odds of that happening? Slim to none. Shannon 7, thank you very much. Would it have been better if the other charges had never been allowed in? Confusing. That's the argument they're going to make on appeal. I don't know. I don't know how this is going to play for the jury. It's going to be very interesting to watch in closing arguments. We still have a couple of days to go, so we'll see what happens. Peter, thank you. The judge is biased beyond all reason. You can have that perception. Alex Murdaugh will be found guilty and shouldn't be. Money crimes never should have come in. More prejudicial than probative, period. Peter, that's a fair interpretation to have based on the evidence that you had laid out in front of you. I saw both arguments. I didn't agree with the money stuff coming in, but I saw the other side as having some legitimate argument to it. We'll see. I'm not there on the judge's bias. I haven't liked a lot of the rulings recently, but I can see how you can form that opinion, and I have no issue with that. Ellen, do you think AM is pulling an Amber by trying to control his defense? I can't believe his attorneys want this. I don't know what's happening. I want to see tomorrow just as much as you guys do. Nanner, thank you very much. Can things said in this case be used in this financial one? Yep. Testimony under oath can be used again. Ryan Man YYC, thank you very much. Does the judge's will see position put a spoke in the informed waiver of privilege? We're going to have to see that admonishment. I want to see what the judge says. It's going to be very curious to hear how it is laid out in front of Mr. Murdaugh before he decides whether to testify or not testify. 9-Inch Nails Gal, thank you. Would not limiting the scope on cross mean state can question not only the financial but the boat case as well? Could that be the bigger concern? They are going to, at the outset, have the opportunity to cross-examine on everything. It's just a matter of how much the judge reins it in after the initial, call it the initial salvo, like that little back and forth. We'll see how much the judge reins it in. Laura, thank you. Thank you, Rob, for the time you spend with us. It's very, truly appreciated. Also, for forgiving a lot of my misprints. You are awesome. Laura, thank you very much for being here and for the super chat. Professor of Logic, thank you. What is the legality of hooking Alex up to a car battery and shocking him when he lies in the stand? Cite precedent. I don't know that we have precedent to that effect. I think that some people in the chat might have opinions, but we're not going to do that. Not in a courtroom. Teacher Terry, does Alex have to worry about his lawyers or himself opening doors, or is everything fair game on cross if he testifies? This is a good question. The answer is maybe, and you're going to hate it. Maybe. The thing is, if he's saying I have a Fifth Amendment privilege not to incriminate myself for crimes that are unrelated to this transaction, which have been charged but not yet proven, that holds weight. But if he starts testifying that he didn't do these things or starts testifying to those facts, then he opens the door. And the question is then whether he knowingly waived his privilege against self-incrimination or his right to against self-incrimination by talking about that under oath. So it's going to be interesting to see that come to play if it does. Heather, thank you. Mr. Ball said something curious. Didn't want to go to the house because it might be part of the crime scene, but no problems wandering around where Maggie and Paul were. If worried about the crime scene, why even be there at all? The crime scene had been released at the time of this testimony, at the time of this incident he testified to, which means that the state believed that there was no more evidence to glean in that moment. They released the crime scene back to the owner of the property. At that point in time, he went in there saying he was helping to clean up, which is understandable because that's an issue that families have to deal with. I don't think that at that point there's any concern by anybody, and there shouldn't be, that the crime scene was being tampered with because the state had released the crime scene. Stina G, thank you. Do lawyers prep to be witnesses the same as regular people, or is it assumed they know how to testify because they're lawyers too? I will prep a lawyer doubly and triply so, because my gosh, they are difficult to control on the stand. I've never put one on the stand. I wouldn't put one on the stand. I just don't even imagine. That's the anxiety I would have. I don't like it. Emily, public has been critical of the state making it a trial of finances. Maybe defense wants to bring it up, and this was their least bad witness to do it. I don't know. That's a good hypothesis, though. Daria, thank you. I have no problem taking in all of his testimony. I watched it. I just think it was a little slow developing. I want to see it wrapped up on close. Tasana Burfoot, thank you. Do you think Poot, as lead, demanded to examine these big witnesses? I don't know. Or Alex demanded that Poot do it? I don't know. I struggled with his direct examination of the experts. I just didn't think it was as impactful. That Sarah, thank you. Fun fact, my college roommate got her master's degree in forensic science for the University of New Haven. It's a highly ranked program. That's awesome. Thanks for sharing that, Sarah. That's really cool. Molly, thank you. Defense only gave part of the info to review. He didn't see all the evidence before conclusions, never wrote a report, so prosecution never saw a head of testimony and got some info he got yesterday. Expert witnesses are allowed to get info from the actual things they observe in trial. It might feel uncomfortable, but experts are allowed to sit in trial, listen to testimony on the stand, and change their opinion on the spot. It is a unique position, which is why you qualify and vet the experts beforehand. I didn't take issue with all of this because I'm used to this process, but I can see how people who are watching this from the outside who don't engage in this practice on a daily basis feel a certain level of discomfort, which is why I got to the point of the questions being asked. But thank you, Molly, for the input. Joy WRN, thank you. Question, what would happen if Alex admitted to hiring someone to commit the murders if he testifies? State moves for mistrial without prejudice. Brings new charges on the conspiracy. Court grants the mistrial without prejudice because the defendant created the mistrial by his own conduct. I imagine that would be the case. Debbie W., thank you. James, please tell us about the jury's reaction to Buster and the new jury makeup. I'm sorry, Debbie. I will relay that to him via a message. I'll send him on Twitter so he can answer it in his stream if you want to go check that out as well. And also why the jury isn't allowed notebooks. I can answer this one. Jury's not allowed notebooks because it's the rule of this court. Every court varies, every judge varies, every jurisdiction varies on whether juries are allowed to have notebooks or not. So it is a jurisdictional specific inquiry, and this jurisdiction doesn't allow the jury to have notebooks. I cannot imagine going through a 5-week trial without a notebook. Lori Leanne, I'll relay this to James. Is the previous elected attorney general sitting behind Alex? Is AG behind Alex? Notice the difference in how people treat Poot since he's a senator. How Poot treated. Senator. Thank you, Lori Leanne. Very much appreciated. Thank you for the super chat. I will get that to James, I promise. Julie, I love how you guys support each other. Thank you, Julie. Very much appreciated. Tiffany Bernier, thank you. James, how are the hotels in the area? I kind of want to drive down. Tiffany, I'm going to relay that one as well. How hotels? I know that James has been staying there for a while. I think that they are rather nice accommodations, so I'm very curious. NBGSTV. What you said about the audio cutting out too soon. When I was editing film, I got my best takes before action and after the cut for real. Yeah, that's the part that has driven me wild. And I understand why the court does it, because they don't want the hot takes to be broadcast everywhere, because technically speaking, that's not on the record. But I still want to hear it so bad. T-Mac, thank you. What is your opinion on the jury being hung? If it happens, can the state learn from this one and fix their issues, or they have to do the same thing? Thanks. I think that a hung jury is firmly within the realm of possibility. Firmly within the realm of possibility, but I'm not going to pretend to be able to predict what this jury is or isn't going to do. Bringing the case again is going to be tough. There's going to be a lot of exhaustion, and I think a change in jurisdiction or a change in location might be necessary. You can tell me that you can find a fair jury now, or for this case, but now make the argument you can find a fair jury after the televised case. I don't know. So it'd be interesting. Arlene Francis, thank you very much. I see James right above Alex Murdaugh, almost 200,000 subs. Rob, thank you, Arlene, very much appreciated. Yes, if you guys are here, please hit the like button on the stream itself. I'd love to get this video over 5,000 or 6,000 likes. It'd be amazing, and it would just be awesome for me. Please, and then if you like the content, the recaps, please hit subscribe. I try to do these all the time. And then Friday, we have a show recapping the whole week. Robin Silver, thank you very much for the super sticker. Thank you. I very much appreciate it. Compact Roan, thank you. Love what you, EDB, and Runkle do and your openness about ADHD. I loved last Friday Night Frenzy. It was a wonderful conversation. If you guys are interested, scroll forward to the tail end of it. We have a great dialogue about how we all have ADHD and still are able to manage our lives as practicing attorneys. Well, Runkle and I still practice. Emily retired and is killing it on the YouTubes. Bop it. Thank you very much. Sloppy investigation by SLED. Sloppy courtroom practices by both sides is a South Carolina thing. You guys heard James' remarks. It has become so commonplace that I don't know that I can say it is out of the realm of possibility. It just might be how things are done. I've been in courtrooms where a judge has said that's not how we do things, Mr. Morton. And I hate that remark, but I have been there. It's very frustrating. Kristen M96, been a juror in Columbia, not like this. Then again, pre-law tube addition, also Metters hired in January to go against Poot. I completely agree with that. I saw that reporting. I think it was a wise move. They seem to get on each other's nerves, righteously so. It's going to be interesting. But I think we all know who's going to cross-examine Murdaugh if he takes a stand. That's going to most definitely be Mr. Waters. There's no way he's going to pass it up. Blue Bayou, thank you. Conspiracy theory, trials of farce only so they can say they gave it a shot. I cannot imagine with what you have seen in this courtroom that that's a farce. There's a lot of emotion on the state's side in general and on the defense side. This is for their perspective. I can't imagine it's a farce. Amy T, thank you very much. Part of me thinks AM is arrogant enough to testify, but Poot would definitely try to throw everyone off and distract even more and not testify. That's a possibility. Judy, thank you very much for the super sticker. Very much appreciated. WW Rob, he mentioned the notebooks in his day 13 recap. It's because some jurors may be better note takers than others and may hold more sway over the others. It's a balance of power consideration, he asked the clerk of court. That is interesting, Debbie. Thank you for that. I want to read that again. So he mentioned the notebooks, I'm assuming referring to the judge in his day 13 recap. It's because some jurors may be better note takers than others and may hold more sway over others. The balance of power consideration, he asked the clerk of the court. That is actually a legitimate reason why you might not want notes, because if someone goes back there with a notepad, that note might be wrong. And if that note is wrong, and the juror that's there, it says, look, it's on my notepad, I took the note. It allows you to try and strong arm the other jurors into your understanding. If you have to rely off your memory, no one has the added weight that a notepad might give them in that deliberation room. Very interesting observation. Thank you, Debbie, for sharing that. Crumfelt, thank you. As you know, lawyer can't put up a witness to commit perjury. I'm sure Putin and Jim know the truth. It would be very uncomfortable. AM paid them $1 million, so he's going to be honest with them. If they directly examine him, it will be interesting ethically. Oh, Crumfeld, that's a whole nother consideration I hadn't gone down because I was thinking more from the witness perspective. I got to think on that one. You're not wrong. You're not wrong. Jim and Poot have known everything. It's pretty tough. So we'll see who does the direct examination, because the other thing is the jury's going to pick up on if it's not Jim or Poot. One of them has to do it, I think. This is going to be very curious to see. Okay. Thank you guys very, very much for this. Let's go ahead and end that poll and see where we're sitting right now. It looks as though we are right where we were when we began. We have 63% of people that are saying that he is not going to testify, 67 that says, sorry, 62%, 37%, something like that. 3,000 votes. So 37% of you are saying he will. Let's see how many of you are right come tomorrow, because I imagine they will try to put him on tomorrow just in case things go sideways. They're going to have one witness in reserve to try and bring the train back on the tracks. So this is, I'm nervous. Is there a way? Is there such a thing as secondhand nervous? Like the idea that this is going forward and Murdaugh might take the stand is pretty just wild to me. And before we duck out of here, I do want to say this. Thank you for the gifted memberships. Amber's Eclectic Journey, thank you. The Neurodivergent Counselor, thank you very much. CMS, thank you very much. Baby Gator, thank you very much. Brentwood Chic, thank you very much for the gifted memberships. T-Mac, thank you very much for the gifted memberships. All of you who have gifted memberships, at some point in time, they're going to find a way for me to pull those up because they are so very much appreciated. Thank you all for being here. Love doing these recaps. They're great. We've been here for 2 hours and 10 minutes. I wanted to keep this to an hour and a half. I lost again. But thank you guys. I hope you enjoy the rest of your evening, and we will catch you on the next time. All right. Good night, guys.